finally had to figure out how am I going to get her real food with no preservatives, nothing artificial, just pure food. Happy Hal. So go to dollyfood.shop. Dollyfood.shop. What do you think, Dolly? You like it? I think she likes it.
Welcome to Worldview Tube's Washington Report on April 1st, 2026. I'm joined by Jim Pfaff of the Conservative Caucus.com, and it is a busy day in Washington, D.C. President Trump had a drive to the Supreme Court this morning. Here is just this motorcade driving down on the way to hear and sit in on the case on birthright citizenship. And we'll have plenty of clips on that, of the arguments on the case and more, as well as President Trump is scheduled to have an address to the nation tonight at 8 p.m. Central, 9 p.m. Eastern time. So we'll be covering that later on tonight.
Let me throw in here on Donald Trump going to the Supreme Court, because this is a rare thing. But keep in mind, there's a chair for the president that's been in the Supreme Court like forever. But it is a rare thing. But what I want to point out about this, because the left and Democrats are just, and even some in the media are just, they're having a gasket. They're blowing a gasket over all this. And there is a problem in Washington, D.C. that makes it what we used to call it the swamp, and that analogy is good because it was built on a swamp. But as Congressman Tim Burchett says, and I agree with him, it's a sewer. The reason it's become a sewer is because of certain precedents and ideas and ways of doing business that shut out the American people's input once people get elected. People go to Washington, D.C., they do their thing. We've got an entrenched bureaucracy in the administration that Donald Trump is obviously taking on, but it still exists. And they do their own thing, and they don't even care and just stay out of my way. And by the way, we don't even like this president guy because we're the ones that run the government. That attitude can only be broken up by breaking the kinds of precedents that allow it to continue to metastasize constantly against the American people. I'm all for Donald Trump showing up at the court. The three branches of government certainly have their own lane that they can go into, but that does not mean that they're not influenced by one another. The Supreme Court has justices that are appointed by a president, confirmed by a Senate. So it's not like there's no accountability at all. And I think it's entirely appropriate if any president wants to do such a thing. And we have said, oh, well, no, we don't want to unduly influence a different branch of government. These branches of government are unduly influencing one another all the time. The executive branch has been constantly influenced by the other branches. I mean, the Congress influences the executive branch because it determines what money it can spend and where. Mm-hmm. And the Supreme Court cuts down executive branch ideas at times because they'll rule against it. So these interactions are happening all the time. Kudos to Donald Trump for breaking the logjam that has, for whatever reason, has kept presidents on serious issues from at least showing up and making an appearance.
Yep, and we have plenty of clips on this with the U.S. Solicitor General John Sauer. Is that who he's Sauer, arguing the case. Let's go to this first clip of John Sauer making the case to Justice John Roberts. Here we go.
Well, starting with that theory, you obviously put a lot of weight on subject to the jurisdiction thereof. But the examples you give to support that strike me as very quirky. You know, children of ambassadors, children of enemies during a hostile invasion, children on warships. And then you expand it to the whole class of illegal aliens are here in the country. I'm not quite sure how you can get to that big group from such tiny and sort of idiosyncratic examples?
There are those sort of narrow exceptions for ambassador foreign public ships. Tribal Indians is an enormous one that they were very focused on in the debates as well. But what I do is I invite the court to look at the intervening step, which is the enactment of the Civil Rights Act of 1866. And there they didn't say subject to the jurisdiction thereof. There it says not subject to any foreign power. Now, if you go back to Blackstone and Calvin's case, they say it does not matter if you are subject to any foreign power. If you are born in the king's domains, you have this indefeasible duty of allegiance to the king at any time. So there's a clear repudiation in the Civil Rights Act. The Civil Rights Act is this breakwater which makes it very, very clear that they are not thinking about allegiance in the terms of like the British common law. They've adopted the Republican conception of allegiance. So it's from not subject to any foreign power, and then the debates just a couple months later make it very clear that they're recodifying the same conception. They were dissatisfied with the potential ambiguity in the phrase Indians not taxed, and they adopted subject to the jurisdiction thereof. And one of the strongest statements of this is Senator Trumbull's statement that I quoted at the beginning, where he says, he's asked, what does that mean, subject to the jurisdiction thereof? And he says, it means not owing allegiance to anybody else. That is what it means. And this court picked up on that in Elk against Wilkins when it says, it uses, completely subject to the political jurisdiction, not mere regulatory jurisdiction.
What do you...
All right. So in essence, they're arguing about what it means subject to the jurisdiction thereof. And he's citing, saying that it means not allegiance to any other country. And he's saying that applies to these illegals. They have to pledge allegiance to America and no one else.
Yeah, well, it's not so much. It's not. He's not in. What he's talking about is the pledging allegiance argument of the British common law was a duty to do so. But in the United States, there's a distinction. There is an actual citizenship status that exists. And what he's saying is, you have to rightly be subject as a citizen to the United States, which I believe is the clear language of the 14th Amendment, which says, citizens born in this country and subject to the jurisdiction thereof. That and this is the argument. What does subject to the jurisdiction thereof mean? Mm-hmm. This is where it's kind of gotten off base, and what the government is arguing through John Sauer as Solicitor General is that the jurisdiction subjugation is based on citizenship, and that what the authors of the 14th Amendment were doing after, by the way, hours and hours of debate on the issue, much of which supports, I believe, the government's argument, is that they were trying to cure this problem of slaves not having been citizens prior to their emancipation, and curing that problem by declaring them citizens, and noting that for various reasons they were subject to this jurisdiction by various means, and previously through ownership as slaves, being owned as slaves. So when that transition took place, they wanted to make sure that that black slaves who had no connection to any other country prior to them being forcibly put into slavery or being descendants of those forcibly enslaved here would be able to enjoy the rights of citizenship because they had no connection to any other country at all prior to that. So that's what the 14th Amendment intended to fix. When Donald Trump yesterday was saying this is about curing that problem with slaves, that is entirely what the authors of the 14th Amendment were trying to do. And in all of their arguments about how to go about doing that, you came into all these other discussions that the ACLU lawyers attempting to argue today might be relevant. And all that the authors of the 14th Amendment were attempting to do was make sure that black slaves would be considered citizens now that they would be emancipated, which the 14th Amendment emancipated them. That's the other thing. The whole construct of the 14th Amendment is to deal with the issue of slavery and to provide a constitutional emancipation for them. So anyway, it's lawyers that get confused about all this. Mm-hmm. And lawyers get confused about it, not so much because they're confused, but because they're attempting to accomplish something. And those who caused us to automatically change this standard in the 20th century, where we had just assumed that anyone born here is a citizen. that standard has been wrong and lazily gotten into. And Donald Trump rightly is trying to define precisely what it is, particularly when you look at the fact that there are people obviously abusing that precedent that was lazily set through what we do, not through what the law was. So this is a really, really important issue. You've got people in China, there's just one example, there are others, but people in China that are doing birth tourism. Mm-hmm. We know of the example of one Chinese billionaire who has had 100 children with women who were born here in the United States, and he's trying to confer citizenship on them. They're utilizing a loophole that really doesn't exist in the law to try to undermine the United States. There are estimates that there are tens, maybe hundreds of thousands of these birth tourists that have come into the country from China alone. This is a really the issue that Donald Trump's trying to deal with through his executive order, and I think he's right to do so. We need to clean this up again and once and for all and for good. And by the way, when I'm listening to the arguments, I'm not sure, certainly, where Kavanaugh, Gorsuch, and Barrett stand on this. This might get shot down, and then we are going to have hundreds of thousands of people who are going to be conferred citizenship, many of whom were done so in a weaponized fashion.
Yeah. And let's go to this clip of Justice Samuel Alito, where he suggests that just because illegal aliens were not around at the time the 14th Amendment was adopted does not mean they should not be addressed. Watch this.
That they had in mind when they adopted the general rule, or do we say they adopted a general rule, they meant for that to apply to later applications that might come up? Justice Scalia had an example that dealt with this situation. He imagined an old theft statute that was enacted well before anybody conceived of a microwave oven, and then afterwards someone is charged with the crime of stealing a microwave oven, and this fellow says, well, I can't be convicted under this because the microwave oven didn't exist at that time. And he dismissed that. There's a general rule there, and you apply it to future applications. And what we're dealing with here is something that was basically unknown at the time when the 14th Amendment was adopted, which is illegal immigration. So how do we deal with that situation when we have a general rule?
Yeah, I strongly agree with the way that you framed it, that there is a general principle, that's a broad principle that's adopted in the phrase subject to the jurisdiction thereof. And we submit that our theory of allegiance and domicile-based allegiance is what explains those specific exceptions that everybody was aware of, but it is broad enough to sweep in future situations. And as you pointed out, illegal immigration did not exist then. Now, the problem of temporary visitors did exist. And it's very interesting that as you look at pages 26 and 28 of our brief, commentators going from 1881 until 1922 are uniformly saying the children of temporary visitors are not included. Now that logic, we say, it naturally extends. It's really an a fortiori case. If you have someone who enters illegally by the 1880s, there are restrictions on immigration. If you've entered illegally, it's kind of a well-established principle of law going back to the Code of Justinian that says you're not allowed to be there. You don't have the legal capacity to create domicile there.
But I think, General Sauer, that what you just said suggests that you can't be arguing in the way Justice Alito suggests, because most of your brief is not about illegal aliens. Most of your brief is about people who are just temporarily in the country, where there was quite clearly an experience of, an understanding of, that they were going to be temporary inhabitants.
All right, Jim.
The real challenge here is what, if anyone who's listened to this debate and listened to what Amy Coney Barrett was arguing, it is a standard of jus soli, jus sanguinis. Jus soli relates to of the land. Jus sanguinis is of the blood, meaning parents. Now, what is being argued is that Donald Trump is pushing for a jus sanguinis standard, connected to your parents and where they live, and that he's rejecting a jus soli standard, which is of the land where you happen to be born. And the thing is, I would argue, and I was surprised that Justice Barrett didn't really dig into this. There was a real bifurcation in the 14th Amendment of the jus soli standard. And that's what's entirely being argued here. If you are born in a country, you are not conferred citizenship really anywhere. There's no standard, and not a clear standard, in the British common law, which had said specifically that if you were born in that country, you must subject yourself. Like it went beyond just what you were born into. It went into now you must show allegiance. And the 14th Amendment wanted to clarify that by making it clear on the jus soli standard, the where you were born standard, that these what I want to say, descendants of black slaves, they were forced in here because their parents also were subject to where they were forcibly brought into or born themselves. And so this is where this argument is going to get really complicated and can be very complicated because of lawyer speak. And I would argue that to say that that just because you were born in a place makes you a citizen of it, that you just don't, there's no legal absolute precedent in that regard, unless done so by legislative act. And in the British common law, that was specifically done. Mm-hmm. But that was never done here. And we really have not passed any laws, by the way, to enshrine this. Remember, in the 14th Amendment, there's the clause, the typical clause in many amendments to the Constitution that says that the Congress has the ability to make laws thereto. If Congress wants to pass a law to do this, they can do that. It has never passed such a law. And so we're arguing from the constitutional base, which I think clearly states and clearly shows that there was a sincere attempt to make sure that black slaves could become citizens. That is clearly what was there, and all the arguments in the debate over the 14th Amendment centered around, well, how do we clarify that in the language itself? And the language we came to was based on that clarification, not some ambiguous misunderstanding of, well, should we also include those who are here on a temporary basis under other means? And that was the clarification and the purpose of the 14th Amendment. And I think the court, to be constitutionally consistent, needs to rule that the executive order is appropriate, that the president may assert that through executive order, which doesn't have the force of direct law unless if it contradicts what Congress wants to do. And if Congress wants to change this in the future, they can. And to be candid, one way or the other, I can guarantee you that Democrats will attempt to do that through law, and they will have a right to do it if they can pass it and get it signed by a president. So that is also in part what's at risk here. Like, this whole argument's not going to be entirely over until the whole belief system behind conferring citizenship to anyone that happens to be born here is shut down forever through the failure of some attempted congressional act in the future to give citizenship to those who were just born in this country, notwithstanding the situation of their parents.
Yep. Yeah, well, we have to go to break, but we'll keep covering it. And President Trump departed, and now he has a speech tonight, and we'll see what he says there about this case as well. But we got to go to break and come back in just a moment.
Go to worldviewtalk.com. Get your satellite phone like I have, because you know what? China is in on our power grid. That is a matter of proven fact. If you want to have communications with your loved ones, your family, your children, maybe your spouse travels, maybe you have a child away at college, you want communication should the grid go down. That's why you need a satellite phone, worldviewtalk.com. But look what else they have. They also have solar generators. I have one of their solar generators. I have the Delta Echo 400, a solar generator. So I can, of course, charge my satellite phone. I can run my coffee pot. I can run my whole house if I want to. All the details are there at worldviewtalk.com, or use that number, 1-866-738-3224. They have very friendly operators that will explain to you their products, but you can explain to them what it is you're desiring to acquire. How much electricity are you wanting to generate with this solar generator? Well, they'll tell you what size you need. Worldviewtalk.com or 1-866-738-3224.
All right, welcome back from the break. Jim, I want to play just one clip of Justice Ketanji Brown Jackson before we move on. Let's listen to this one clip real quick.
And who would not qualify under your rule. How does this work? Are you suggesting that when a baby is born, people have to have documents, present documents? Is this happening in the delivery room? How are we determining when or whether a newborn child is a citizen of the United States under your rule?
And I think that's directly addressed in the SSA guidance that's cited in our brief. What SSA says is there's currently a system where, for example, Social Security numbers are generated based on the birth certificate. They say this can still be, for the vast majority of instances, completely transparent. You will still get a...
Not transparent. I'm just talking about the particulars, because now you say your rule turns on whether the person intended to stay in the United States. And I think Justice Barrett brought this up. So are we bringing pregnant women in for depositions? What are we doing to figure this out?
No, as I pointed out earlier, the executive order turns on lawfulness of status. So,
all right, I just wanted to point out there, she had to say, are we bringing pregnant women in for depositions? What about pregnant men, right? She can't define what a woman is, right?
Yeah, well, the inconsistency is obvious and glaring. Not to mention that little exchange, which I actually did listen to, just proves again how she's unprepared. She's not very intelligent about what she's doing. She doesn't have all the facts of the background. She's seeking a specific outcome, and which just happened, by the way, yesterday, where Kagan and Sotomayor departed with her on a key decision as well. So she's not the brightest bulb in the box, I can promise you that. But, you know, this is an example of one of the basic problems we've had in this country for decades, where we have changed the way we do courts so that to do two major things. First of all, courts have been made the final authority on all matters of truth, which has never been envisioned in Western law, because courts were always designed to be places where, you know, going all the way back to the Mosaic Law, where there are disputes about what the situation is, and you just need an arbiter to help work through that. That was our whole intention for courts forever. That is the Western concept. But we've turned it into final authority. Courts were always designed to, and this is why Moses was told by Jethro, you need to stop doing all these cases yourself. You're going to kill yourself. You need to spread it out among good men who can take the lesser cases and you take the big ones, because you can't decide everything in a court. They were all discrete matters at law. Moses didn't make a ruling and then everything that came to him, he didn't have to take it, or it couldn't go to court at all because, well, I already said what it is, so it's done. Well, situations differ. Discrete cases at law is what should happen. That's the first thing that's changed. And that's an important one, because we make courts the final authority on all things. The second problem is that you've got an idea of jurisprudence that has been growing and growing and growing since the Warren Court in the 1950s that says that that courts, because of this final authority structure, now can determine what law really means when courts are supposed to be constrained by either legislative process or constitutional language on that specific case. And so we've changed that as well. Antonin Scalia spent a lot of time changing this way of thinking, but courts have been our legislative process in key areas of what we do in this country, and Ketanji Brown Jackson wants to do that as well. Listen, you can argue the merits of this case, and there are arguments to be made on both sides. The question is, are we going to conform ourselves to some desired legislative outcome, or are we going to conform ourselves to really understanding the intent of the law and the constraint of the law? And Ketanji Brown Jackson, she's not there. She has a social agenda that she wants to impose, and Sotomayor and Kagan, in most cases, do the same thing.
Yep. Well, in other news, President Trump signed an executive order making mail-in voting more secure by multiple different things. DHS to create a list of U.S. citizens with the help of SSA. USPS only sends mail-in ballots to approved voters, and so on. But guess who's suing? It looks like California Governor Gavin Newsom is challenging it and says, we'll see you in court. Why would he want to challenge this? I know why, but is there another reason? Are they going to give another reason other than to stop illegals from voting?
He wants illegals to vote.
Yeah.
That's why. But interestingly, this is a brilliant move by the Trump administration. The post office does have legal authorities in terms of how it handles mail. It has responsibilities, of course. Those are there and laid out. But it's not one of the things that cannot happen through the mail is you can't undertake fraudulent activity. So to help ensure that the voting process is not fraudulent through the means that this executive order implies, which is to put some form of coding on mail ballots, is absolutely appropriate. You can't have fraud going through the mail, and there's lots of fraud that goes through the mail. So this is an interesting case that Gavin Newsom is going to bring up in light of the fact that there's a man in California court just this week who is probably going to go to jail because he was receiving, I think the number was like 67 ballots or something like that, at a residence he was at, and then moving those votes into processing. I mean, this is literally happening this week at the same time. Yeah, you found it. At the same time that Gavin Newsom is wanting to challenge this approach by the post office. He has no authority over the post office, but you're going to have some judge overturn it, and they're going to do it on some basis that is not connected to law. It's just going to be because we don't want to do it, and Donald Trump tried to do it. This insanity, TDS, this belief that we are going to still have to fight against, that anything Donald Trump does obviously has to be fascist and dictatorial. This is the idea of many judges, and it's clearly the idea of Democrats, and they're not going to back off of that. They want complete, utter control over the American people, and they are seeking to overthrow the American Republic. By the way, you just had Nancy Pelosi. I should have sent this to you, but Nancy Pelosi made a statement recently where she said, yeah, we're going to watch these elections clearly, so Donald Trump doesn't take over the voting machines. Well, why are you saying that? I thought you told me the voting machines were fine.
Yeah.
I thought that everything was secure and safe. We don't have anything to worry about. It's farcical at every level.
It really is. It really is. Well, we just have about time for one more clip, and I think this is a good one to close it out on. Speaking of voting, here's Rep. Omar on the Save America Act. Watch this.
We are looking at in Washington, D.C. is the SAFE Act, which is a piece of legislation that is in regards to, they say, creating a safe election, and we say it is a bill that disenfranchises half of the population in the United States. It's a bill that requires for people to show a proof of citizenship. You know that majority of married women who have changed their names, who might not have access to their original birth certificates and all the documents that they need in time to be able to vote on any of the primaries that are happening in the next few weeks, few months, or the November election.
All right. Well, She says it's going to disenfranchise half the country, and the argument she makes about the married women, and that's all been proven wrong, and they've put stuff in place for that. So I mean, the argument's not really there.
Yeah, not to mention the fact that married women who change their names have been voting forever anyway. Yeah. So and already are proven citizens through their various forms of ID. They're going to throw anything up against the wall they can to inject fear, or what in the crypto community has been called FUD, fear, uncertainty, and doubt. Mm-hmm. That's their only argument right now. On a practical basis, this is not a problem. One, two, as you rightly point out, the bill, has provisions to deal with that. And three, you still have to undertake these processes because only citizens should be voting. Yeah, that's the way it is. They just want non-citizens to vote because they think it works for them. And the fraud in Minnesota proves how bad a situation can come about when you allow that.
Yeah, and I don't think the goal should be to make voting as easy as possible. I mean, it should be easy for a citizen, but I mean, there's got to be rules in place. There's got to be something in place to stop voting or illegals from voting. And
no, absolutely. This is going to be a serious issue that we're going to be fighting for a long time still, because these people are intent upon overturning our elections and overtaking our American republic. That's what Democrats are about.
We're all out of time. We'll be back tomorrow. Until then, stay tuned for Trump's announcement tonight on worldviewtube.com. Take care.
True beauty isn't applied. It's nourished from within. Bella Grace Elixir, a luxurious, scientifically crafted blend designed to restore radiance, vitality, and strength at a cellular level. At the heart of Bella Grace Elixir lies cat's claw, a powerful herb from the Amazon known for its ability to control inflammation and protect collagen. With Verisol collagen peptides, it goes